May it please the Court. Michael Uffman on behalf of the appellant, Brian Tuck. I'd like to reserve 5 minutes of my time for rebuttal.
You got it.
I'll focus my time this morning on the first issue raised in the briefs, and that is whether the evidence was sufficient in this case to sustain the sexual battery conviction. In my briefs, I've relied upon this Court's Thornton case, and in Thornton, the Court explained that a sexual battery allegation involving an object must be based on evidence of penetration. And in this particular case, when the alleged victim testified at trial, and this appears on page 161 of the trial transcripts, when asked about the incident in question involving my client's fingers, she said that he, quote, dabbed it. And I submit, and as I've argued in my briefs, dabbing it would not amount to penetration under Thornton, and therefore there's insufficient evidence.
I looked up dabbing in the dictionary, and I realize we're talking with a very young child, but dabbing means to touch lightly, like you're dabbing paint on an easel. It doesn't denote any kind of penetration.
Correct, Your Honor. And I submit that her in-court testimony simply does not establish penetration and would be insufficient under Thornton. Now at trial, the state in its closing argument, and then on appeal, the state in its answer brief is relying upon the alleged victim's out-of-court pre-trial statements, her child hearsay statements that were made to law enforcement or a child protection team investigator, as the sole evidence to establish penetration. And it is true that out of court, prior to trial, the alleged victim did make an assertion of penetration. However, as I've argued in my briefs, under the Florida Supreme Court's opinion in Green, and then as confirmed in the Baugh case, an out-of-court statement by itself is insufficient to amount to the only evidence of guilt, especially...
But in Green involved a complete recantation of the prior accusations.
Green did. I think Baugh, which was cited in the state's answer brief, confirmed the holding in Green, and Baugh was a case involving the new statute that allowed for child hearsay statements to be admitted as substantive evidence. But again, the Supreme Court confirmed that in a case like this, when you're dealing with an essential element of the offense, there must be in-court testimony to establish that essential element. The state cannot rely solely on child hearsay or an out-of-court prior statement for that purpose. Baugh also cited to the Bieber case from the Florida Supreme Court.
Did the defense request a instruction on what is meant by dabbing? Was there a definition given?
Well, certainly that's not something the defense would have to do.
So what I'm saying is that then it's up to the jury to use their present sense impression of what this child means by using that phrase in the context of her entire testimony, taking into account whether that amounts to an inconsistency with the prior recorded conversation.
Oh, I think dabbing it is inconsistent with penetration.
Is that a matter of opinion or a matter of fact?
I would think a court reviewing...
Or a matter of argument that was made below.
It was not a matter of argument that was made below, and obviously I've alleged that and tried to explain that in my briefs. But as far as a court reviewing evidence, I submit that this court, the conviction can only be sustained if the evidence is sufficient. This court is required to review to determine if the evidence is sufficient. You can review as to whether or not dabbing being the in-court testimony would be sufficient under Thornton to establish penetration, and in dabbing being inconsistent with an allegation of penetration from the prior statement that was asserted to the child protection team. So I submit that absent some allegation during the trial from her in-court testimony of penetration, that would be an inconsistency between saying dabbing it at trial and then saying penetration prior to trial, such that under Green, under Bieber, under Baugh, there's no way that this court could affirm the conviction.
Let's assume we agree with you on that. Where are we then with the kind of boilerplate motion for judgment of acquittal that was made at trial?
The best argument I can make to the court, and I've cited to this court's RS opinion, and I'd like to quote from that. In RS, the court explained that the trial attorney stated, quote, "Make a motion for judgment of acquittal at this time. I don't believe the state established a prima facie case of grand theft against this child." The court went on to explain that although this objection is weak, it is enough to preserve a sufficiency of the evidence objection. The motion for judgment of acquittal in this case is identical to the one in RS. I'm aware of the FB case. I obviously cited that in my brief. The only distinction that I would point out for the court between FB and this type of case is FB, the issues raised for the first time on appeal as fundamental error when there's been no motion for judgment of acquittal at all at the trial court level. And at least in this case, there was a motion for judgment.
Let's suppose that the defense attorney had made a better motion for judgment of acquittal and expressly raised the point about penetration, and that we had a problem here. Couldn't it, at that point, the state have sought to recall the child victim and eliminate, or at least attempt to eliminate the uncertainty about her testimony?
At that point, I think defense would argue that you've already said dabbed it, and dabbed it has a particular meaning, doesn't mean penetration, and now if you're going to change that testimony, that makes your testimony inconsistent. And I think that to the extent that they were trying to rely upon the prior testimony, that would be insufficient under Green. So again, obviously, I wish defense counsel would have made a better argument, but under RS, it's the same argument. And the distinction between the argument that's made in RS and what was considered by the Florida Supreme Court in the FB case is that there was no motion for judgment of acquittal at all in FB. And at least in this case, there is an argument from defense counsel that the evidence was insufficient and the court should grant a judgment of acquittal.
Just for my information, can you enlighten us on what was the separate or different conduct that was charged to support the lewd and lascivious count?
Your Honor, I need to grab the information for that. The information appears on page 25 of the record. And the state simply alleged the same time frame as the sexual battery count between June 1st, 2009 and December 25th, 2010. And they just said did on one or more than one occasion intentionally touch in a lewd or lascivious manner the vagina of the person less than 12 years of age or forced or enticed VC, the alleged victim under 12 years of age, to so touch the perpetrator. So that's the allegation. That would have
been consistent with the dabbing.
Is it inconsistent with?
No, I said it would have been consistent with just a touch.
That's right.
Not a penetration.
That's right. And then, of course, where I am today in front of this court, my client stands convicted of both count 1 and count 2. My argument today relates only to count 1. I'm asking this court to grant the same relief that you granted in Thornton. In Thornton, the court found that there was insufficient evidence to support the sexual battery conviction because there was no evidence of penetration. And in Thornton, the court reversed the conviction to the lesser offense of battery. I'd ask that you do the same thing for count 1. Of course, that keeps count 2 in place, and I don't have an allegation.
What was the sentence on count 2?
He was sentenced to life on count 2 as well. Now,
concurrent, though.
Concurrent, and the only distinction is, of course, that the sentence on count 1 is a mandatory sentence of life imprisonment. On count 2, the court had discretion to sentence anywhere between 25 years minimum mandatory up to life. And if count 1 is vacated by the court, as I submit it should be, because the evidence is insufficient, that would certainly open the door for my client to go back under 3.800C and ask the court to reconsider that life sentence. The argument, of course, would be...
Assuming that we agree with you on count 1, is he entitled to resentencing with a corrected score sheet?
Yeah, well, no. I mean, the argument that the state would make is that the score sheet is irrelevant in this case because he was subject to a 25-year min-man under the lewd and lascivious statute that's in place. Lewd and lascivious now says that if you're convicted, the judge is required to impose a 25-year min-man and can give up to life. And the judge in this case gave life. I can make an argument that the judge, and I think this is probably true from a practical standpoint, when the judge sees that I can give anywhere from 25 years to life on count 2, and I'm required to give life on count 1, I'm just going to go ahead and give life on count 2 regardless. I submit that there's an argument that this case should be sent back for resentencing on count 2 so the judge can consider whether the court would have in fact given life on count 2 if there was not a life sentence on count 1. Even if the court doesn't agree with that assessment, again, Mr. Tuck would have the ability to go back in front of the trial court pursuant to 3.800C and make that same argument. And if the court would be open to that, I would at least give him an opportunity for something, some sentence less than life, potentially as low as 25 years. So again, for all those reasons, I submit that the evidence in this case simply doesn't establish penetration. Dabbing would not be sufficient for penetration. Her prior inconsistent statement would not be sufficient under Green, and therefore this court should reverse the conviction on count 1. Thank you.
And you're going to rely in your brief to your other arguments, your other issues on appeal?
Your Honor, I've waived Claim 2 in light of the Florida Supreme Court's opinion in Droughty. Claim 3 is more of an issue of preservation regarding the minimum mandatory sentence. I know this. I won't spend this time with the court on that. And count 4, I think I'm right. I think this court has clearly said that when a county ordinance is a prerequisite to imposing any type of a cost or assessment, then the court or the judgment must cite to that county ordinance. And I think the remedy would simply be to send it back so that the judgment can correctly reflect if there is a county ordinance, because if there's not, then this particular assessment cannot be imposed. Thank you.
Thank you.
May it please the court, Dawn Tiffin representing the state of Florida. I too would also like to focus on issue 1 for the remainder of my time. But I would like to start with preservation. I know the court had a couple of questions about that. What's very interesting about this case, in addition to the boilerplate motion for judgment of acquittal, was the fact that penetration, or the challenging to the state's evidence of penetration, did not factor into the defense strategy. If the court were to review the closing arguments, it would see that trial counsel focused on 2 things. 1, that no sexual abuse ever occurred at all. And number 2, that it was very possible that someone else was the perpetrator, specifically the victim's older brother, who was older by about 1.5 years. And that is what was focused on throughout the questioning. It was weaved through all the questioning of the state witnesses, as well as the defendant, and also through closing argument. It was also set up during opening statement. So I think that that fact is telling with regard to the preservation issue, that trial counsel had no intention of actually challenging the state's evidence as to penetration. Rather, it was more about the credibility of this little girl as to whether any sexual abuse had occurred at all. And again, if so, whether it could not have been her older brother as the perpetrator. We have talked a little bit already about dabbing versus penetration, and I think that is an important point to note, that the very fact that we're trying to distinguish between what those 2 things are, if there is indeed a distinction in this case, that's a question for the jury. That's not...
Wouldn't you agree if you look up the word dab in the dictionary, it does not denote any kind of penetration. It's more of a light tap or something of that nature?
Well, I would say as adults, that's probably our most common understanding in our vernacular. I don't agree at all to the extent that the court might be suggesting that this child, this 8-year-old victim, made a distinction between those 2 things. I do want to take this opportunity to correct something in the state's brief.
Before you leave that, she was subject to cross-examination.
Yes.
So if she is giving the jury the impression that she's using the word, and she's referring to dabbing the inside of this vagina, that would be consistent with penetration versus dabbing the outside. We don't know what area she was specifically referring to, because it wasn't developed on cross-examination.
That's
but it could have been.
It could have been.
The tape was played, which went into a lot more detail and didn't use the word dabbing.
Well, the tape...
So there's not necessarily inconsistency on the face of the record between the testimony and the tape.
That's absolutely correct. That's absolutely correct. She did not use the word inside at her trial testimony 1.5 years later after the CPT interview. But I do want to be very clear that during that recorded interview, she used the word inside and she used the word dabbing. So I believe, based on the record, that she did not distinguish between those 2 things, that rather she was indicating that the penetration happened rapidly and on more than one, there was more than one penetration in that incident, in an individual incident. And that's entirely consistent with her trial testimony. Again, her trial testimony was not as specific, but it does not follow that it was inconsistent with the prior statements that she made during the CPT interview. And what I wanted to correct from the state's brief is we had indicated that the visual recording was not part of the record, and indeed it is. So I wanted to point the court to exactly the location within. It's located in Volume 2. You might miss it if you weren't looking for it, but at approximately 34 minutes and 34 seconds is when that very specific questioning arises. Ms. Berta asks the victim, how did he touch you? And that's when she uses the word inside, and then she immediately follows it with a using of the word dabbing and has some physical gestures. So I think it's important for the court to look at that. Again, to emphasize the point that this child likely did not distinguish between those two things. They're entirely consistent with her trial testimony, and at that point it was up for the jury to decide. Again, it wasn't part of the defense strategy, so it wasn't challenged, and the jury certainly had the evidence before them whether or not this young victim was credible. She was 6 when the abuse started. She was 8 when she gave statements to the CPT interviewer, and she was just under 10 years old when she finally testified at trial. But again, as long as there was competent evidence to get it to the jury, and that's really what we're talking about. Fundamentally, when we are challenging the sufficiency of the evidence, we're questioning whether a jury comprised of reasonable men and women could have reached that verdict. And here the answer is clearly yes. They had evidence that this defendant's finger penetrated the young victim's vagina. And that's all they needed to get the case, to decide it for themselves. So I believe that the trial court made the correct determination here, regardless of the boilerplate motion for judgment of acquittal. Unless the court has any other questions, I'll rely on the state's brief for the remainder of the issues.
All right.
Thank you.
Thank you. Ms. Duffman, you've got your 5 minutes if you want to use it.
Thank you, Your Honor. May it please the court. These are difficult cases. I acknowledge that. You're dealing with a child witness, and it's not easy to go over what may have been alleged abuse. Of course, my client has maintained his innocence. That being said, the state nevertheless has the burden. And let me repeat that. The state has the burden. Judge, you asked, could it have been further developed on cross-examination about what she meant by dabbing? That's not the defendant's burden to do at all.
But it wasn't argued on the motion for directed verdict.
Well, and I disagree. I don't think a defendant has to, you are correct as far as was that specific issue argued. No, it wasn't. I've acknowledged that. I wish defense counsel.
I guess what I'm hearing is in the context of the entire case, including the tape and the testimony, taken together, is that sufficient to survive a boilerplate DV? That's your
my argument is no.
issue.
And I don't agree with the state respectfully that your position to the jury or your theory of the case has to be consistent with the argument you make in a motion for a judgment of acquittal. Of course, many times it's not. You can have alleged murder cases or murder cases where they charge first-degree murder and the defense is, we didn't do this at all, but when the jury's out and you're making your motion for judgment of acquittal, you're saying, hey, there's no evidence of intent. The most this could be is manslaughter or second-degree murder, and the jury never gets to hear that, and it makes no difference that your theory to the jury is that my client's innocent. So I don't agree with that. I acknowledge that, again, this specific issue was not made, but the burden is on the state. And we've read these transcripts. These transcripts are hard to read sometimes, but the state, and I've never been a prosecutor, I've certainly never been in a position of having to question a child witness, but we've seen it done. You have to do it if you want to establish the elements of this type of offense. This is a capital sexual battery case. My client is looking at mandatory life if convicted. So therefore, the state can't use these vague references in an effort to prove its case that puts my client away for life. It's their burden to establish each and every essential element of this offense. The essential element of this particular offense is penetration. So even though it may be uncomfortable and we may not like using the terms that need to be used, the prosecutor is required, when the alleged victim is on the stand, and not the defense attorney and not through cross-examination, they don't have to do anything. They don't have to ask a question on cross-examination. They don't have to present a case. The prosecutor has to stand up with that alleged victim on the stand and have that alleged victim say that this defendant penetrated my vagina in order to establish this type of case. And they didn't do that here. In the courtroom, when that alleged victim was on the stand, however uncomfortable it may have been, she simply said he dabbed it. And this court has a responsibility to review that record to determine, is dabbing it enough for penetration to send my client away for the rest of his life? And it's simply not. Dabbing it does not equate to penetration. The only evidence of penetration is an out-of-court statement, and that's insufficient to sustain my client's conviction. Thank you. I'd ask this court to reverse count 1.
Thank you. All right, we're going to move on to the next case. Apakatos. I apologize if I didn't say that right.